So we jumped around a little bit. You can read the exceptions in between here if you want. They're all very specific, so I'm not going to go into all of them. So that's why we're here at 803.18, statements in learned treatises, periodicals, or pamphlets. A statement contained in a treatise, periodical, or pamphlet is admissible as an exception to hearsay if the statement is called to the attention of an expert witness on cross-exam or relied on by the expert on direct. And B, the publication is, and B, just to be clear, so A and B need to be present. And the publication is established as a reliable authority by the expert's admission or testimony, by another expert's testimony, or by judicial notice. If admitted, the statement may be read into evidence but not received as an exhibit. So if there are excerpts of like scientific journal articles, they are present sometimes in mock trial cases. Even expert reports theoretically could be considered this way. But it has to be documents that are included as exhibits in their entirety in the case. So not just anything that they relied on, and they can't like write fake documents or whatever and read them into the record in mock trial. But what's important to note here is that it deals with stuff that is publicly available. So learned treatises, periodicals, and pamphlets are all publicly available. And if relied upon by an expert, and the publication is reputable by whichever one of these methods, then the fact that it's public record means that it's likely to be beneficial to the jury's conclusions. It's also likely to not be very controversial or subject to the same type of restriction to prejudicial versus probative as other hearsay experts rely on would be. Certainly scientific journal articles more than any of them. But they can't be admitted into evidence. That's different than every single other exception. For all the other exceptions, being able to cite the exception absolves you from inadmissibility. Essentially, it allows you, I say absolve so much now, goddamn. It allows you to admit any of the documents you're trying to, but you cannot admit a learned treatise. It doesn't really matter if you enter in a learned treatise. Juries are unlikely to read it or be able to understand it, or they're in fact very likely to be able to misunderstand it. So reading relevant sections into the record is fine under 803.18, but you cannot enter it into evidence. So if they try to enter journal articles, make sure that they don't. Like it says, the comment there is just about it being documents that are provided in the case materials and not stuff that you went and found outside that helps support your case. But that's Rule 803.18.